Let's address this legal issue. Are you ready, Mr. Chesnoff?
Yes,
and Mr. Lewin?
Thank you, Your Honor.
You've waived your client's presence.
Yes, Your Honor.
He agrees not to be present for this. He's here getting dressed, I take it? Okay. Yes.
Thank you. Your Honor, thank you for permitting me to request reconsideration regarding the admission of evidence related to eyewitness sightings of Kathy Durst when she arrived in New York City after leaving South Salem.
I didn't know I was agreeing to that, but I knew you had a motion of some kind, so
Okay.
go ahead.
As well as other related evidence regarding the New York investigation. Obviously, we have previously briefed this, and we acknowledge that the people, through Mr. Lewin, engaged with us in an effort to figure out a way for this to actually be presented to the jury, and we're not diminishing his efforts by this motion, but we have to bring it in the context of the emphasis that the people have now placed on the failure of the investigation and suggesting to the jury that Detective Struck did not do the things he needed to do at the time without the jury having the benefit of knowing that he did a lot of things that they're not hearing about.
Okay, so time out. The import of the testimony I've heard so far from Detective Struck would be the facts which are elicited, facts regarding statements by Mr. Durst and behavior of Mr. Durst. There was evidence, there was testimony presented about the course of his investigation, I think primarily by the defense, but it also came out from that testimony. Let me say that the motivations of a detective are not relevant except in that line of cases where the probable cause determination is at issue. For probable cause, his conduct may be important. Why he did or didn't do something may be important to establish probable cause, but why he didn't take certain steps doesn't matter. What matters is what is uncovered. So now, I know that you did stipulate to...
You're being asked to unmute yourself. To unmute.
I recognize that there was a stipulation to admission of this testimony, and there must be something in it for you to have stipulated to this, but I will say that stipulating to something that might otherwise have been excluded does not then allow you to bootstrap into admission of evidence that is not relevant, even if it tends to rebut or refute that evidence that came in by stipulation. So that's the premise here. So let's.
Okay,
I
so
want you to understand the court's thinking before you attempt to change it.
Okay.
So go ahead.
Thank you, Your Honor. With that said, the stipulation was entered as a result of the rulings that the court made, because Mr. Durst and his counsel were now in a position where you had told us this wasn't coming in, and we had to make a choice to get in the few bits that might be helpful to Mr. Durst by way of stipulation. Now that the court has seen Mr. Lewin spend over 2 hours telling this jury that if this man had done his job, they would have found out that Kathy Durst had been murdered in the house, and that was the purpose of the examination, Your Honor, and it leaves the jury with the idea that somehow this man was negligent when, in fact, the reason why he didn't seek a search warrant in the house was that he had information from Mr. Durst, albeit that she went on the train. Then he had the information from Cooperman, which was uncontested for 35 years, Your Honor.
All right. Well, still, this is number one. You're trying to bootstrap this, which you have for whatever you have stipulated to this, and now you're trying to because you've agreed to it, now you want the right to
We only agreed
refute
to it because of your initial rulings, Your
Well,
Honor.
no, my
which
initial-
are
no,
m-
no,
most, can-
no,
may I,
no,
may I at least
don't-
make the record?
No, I'll let you make a record in a minute, but
Okay.
let's also be clear about something else, which
Yes, sir.
is that, again, the point is not whether or not Mr. Durst killed Kathy. That isn't really the point. The point is he a suspect such that he believes, I mean, he may be wrongly prosecuted for this. There may be a reasonable doubt as to his guilt, but no one has the right to kill a witness, and killing a witness is a capital murder, and that is the focus of this crime. If he believes that Susan Berman was a witness in a proceeding against him, that is the focus. So whether he killed Kathy Durst is an intermediate fact that may tend to show that he would in fact be prosecuted. You're taking this a step further, trying to raise a reasonable doubt that he is guilty of that offense, which isn't really the point. It is relevant, but it is on the margin of what the case is about, regardless of how much energy the prosecution has put on proving that point. It's still on the margin of what is important in this case. So with that, you may go ahead and make your record.
Thank you. To a trained legal mind who is able to separate and understand the nuanced position that you just took, Your Honor, that is way different than 12 lay people who are spending weeks deciding in their minds whether he killed Kathy Durst. And the fact is that Mr. Lewin, in a few series of questions, could have established that, in fact, Mr. Durst was a suspect, potentially had the idea that Susan Berman had information about it without prosecuting the murder case. But that is exactly what he is doing, and we are stuck with it, and we are stuck with jurors, Your Honor, who are not only being infected by the prosecution of a murder for which he was never charged, and that's the reality of the people that we're dealing with, Your Honor. Mr. Lewin is not doing this because he doesn't have a purpose. He has said over and over again in his questions, he killed Kathy Durst. He killed Kathy Durst. That makes Mr. Durst into a monster, Your Honor.
I'm sorry, relevance is decided by elements. It is the relationship to elements of the crime that I will consider when determining.
Then why are you allowing all the surplusage in, Your Honor, most respectfully?
Your stipulation, period.
We
Okay,
were-
go ahead.
So you're saying that we objected, Your Honor, previously in our motions, and that was denied. But I'll continue, Your Honor.
Yeah, I think you need to focus, be much more specific, and if you...
Let's look
Yeah.
at some of the California cases I cited, Your Honor. If you look at the Livingston case, which importantly quotes the Jefferson, California evidence document or book that you cited yesterday, evidence of a declarant statement that is offered to prove that the statement imparted certain information to the bearer and that the hearer, and that the hearer, believing such information to be true, acted in conformity with that belief. The statement is not hearsay, since the hearer's reaction to the statement that is a relevant fact sought to be proved, not the truth of the matter asserted in the statement.
So you're right. The point, it would have to be relevant. In other words, the action would have to be relevant.
So your position, Your Honor, is that it's relevant for them to present that to the jury, and we're not allowed to establish why that theory of relevancy to the jury is not appropriate in light of the fact that we know that Detective Strzok had 2 live witnesses that placed her in New York. And if you go back to the Chambers holding, Your Honor, We're talking about a real due process issue here.
Let's talk about due process, because due process, I agree if a person's defense depended upon this, but this is not even a defense, it's not even an element of the crime. So again, you're looking about these collateral effects of the admission of evidence, as opposed to the relevance of the evidence. I would not, if this were reliable evidence that could tend to raise a reasonable doubt about the charged offense, or including the charged special circumstance, that would be a different story.
Well,
but
put it in context,
that's not what this is.
But put it in context, Your Honor. If he didn't kill her, then Susan's a witness to nothing. Dr. Cooperman said
No, that's not true. He's accused. There are people who suspect him no
He's
matter
not
what.
accused. He's never been charged.
No, but I mean he's suspected.
Oh,
And the other evidence I understand, which is really more the point, is that he expected to be prosecuted, and he believed that based on whatever evidence was out there, a new prosecution was ensuing, and he acted upon it. And apparently he's admitted that, and that's really the point. Now, I guess if that's not really a good place for you to argue, since he's admitted that, so you're taking a step away to arguing this other thing that is on the margin of what is relevant. And the second problem here is that I don't know to what extent the reliability of evidence goes into a 352 analysis, the prejudice. But here, this unreliable is being a very diplomatic about evidence that has the I mean, by inference, it's manufactured. So I'm not to judge the truth of the evidence. I understand my role there. I'm not doing that, but it's not only clearly hearsay. It's highly unreliable, and.
But most respectfully,
Yes.
Your Honor, we quarrel with this concept that it's unreliable. We had live witnesses. They were interviewed by multiple police. One of them drew or helped draw a diagram or a picture of the person that they saw. He maintained that position for years. The court's aware of another corroborating method used by the police to verify the story.
Right. Go make a record. Go ahead.
Okay.
I just want you to be clear that I think this is far off. I mean, I think this is not close.
I will tell you this, Your Honor.
Yeah.
I have picked up on that.
Yeah. Okay. Pardon my incredulity, but I'm
I
letting you make your
understand.
record. Yes.
The part that's hard for us, Your Honor, is none of us are incredulous, and so we say that with all respect to the court. Your Honor, I was going to quote to Evidence Code 1280, Evidence Code 1331. The cases that I cited are Livingston, or that I was going to cite, Zavala, and Samuels. I gave the court citations. I'll put them in the record now. 113 Pacific 3rd, 1125 on Samuels. 156 Cal Reporter 3rd, 841. It's a case called Zavala. And then the case that quoted Jefferson is Livingston, and that's 274 Pacific 3rd, 1132. All which provide examples of a court allowing declarations that furthered a police investigation, for example, and the reason why a policeman did certain things. The part I'm having trouble grasping, Your Honor, is if the people put on through the stipulated testimony what they believe is relevant, they're going to argue it to the jury. So essentially, Your Honor is saying, even though I might not have thought it was relevant, they're going to get to argue it's relevant, and we're not going to be able to explain, one, why it's irrelevant, and two, why it's flawed. And when you couple that, Your Honor, with what happened with the Myers, where the people put on two witnesses who had, at the time of the event, said specific factual statements, none of which they testified to, or I shouldn't say none, but majority of which they didn't testify to when they were here, then when showed the statement, said it didn't refresh their recollection, but also said that the policeman was wrong. That in itself sets up the argument for us that what Strzok did was effective. And when they have Mr. Strzok being attacked, it bolsters I don't want to call them perjurious, but certainly the disingenuous statements of the Myers. And so I would suggest to you, Your Honor, as a way for Mr. Durst to get a fair trial and due process, that the jury be informed that, in fact, through the parts of the conditional exam which are still available, Mr. DeGuerin cross-examined Struck on most of these issues extensively, that there's an opportunity for the court to cure the damage that's been done by allowing the Myers to testify in a manner that's inconsistent with what the people know they said in 1982. They didn't raise that either. They didn't say to him, didn't you say this? They basically got them to testify completely inconsistent with their interrogations in the early years. Your Honor, I know your position. I've tried to argue this multiple times, but I really think that it's an injustice to Mr. Durst not to have the jury aware of the fact that there were people who saw her in New York, especially when the people have attacked Cooperman on top of it. So this information is corroborative of Cooperman. Now their theory on Cooperman is he didn't know her voice well enough. I mean, Your Honor, at some point in time, we have to be able to tell this jury, Cooperman said this for years and years. He never changed his mind. And oh, by the way, 2 other people who did know her saw her in New York. It's a question, they can attack that. They can say whatever they want about the fellows in New York. They can undercut it. But that's a question for the jury to weigh, the weight of that. It's not to be excluded from them, Your Honor. And in the context of what's happened now in the trial, we would ask you most respectfully to fashion some method for this jury to know about the folks that saw her in New York. Thank you, Your Honor.
People do need to respond.
Go ahead, please. Thank you.
So, first of all, there is absolutely nothing new here. The first issue, and this is incredibly important, the defense is speaking unintentionally out of kind of both sides of their mouth, and this is what I mean by that. They say that they do not want to admit the elevator operator testimony for the truth of the matter asserted, because they can't. But that's exactly what they want to do. The last argument was basically saying, Your Honor, there are people who saw Kathy Durst, and we need the jury to hear that. Now, what's the problem with that? Well, they ignore the fact. Why aren't they able to present that evidence for the truth of the matter asserted? Because for 5 years, 20 different phone calls, emails, individual calls to each member of their team, things lodged with the court, discussions in the courtroom, where I said, listen, if you want to offer the statements of an unavailable witness, and both those witnesses are dead, all you need to do is let me know, and what will happen is their statements will be offered, but if you do that, so will their recantations and other statements they've made. I said this repeatedly, as the court is aware. I lodged a letter, sent an email, to them finally on September 13, 2019, which they're not going to dispute. The letter says, although we have previously discussed this issue informally, this letter will serve as official notice that despite the fact that we are not legally required, absent an express finding by the court of intentional delay or severe investigative negligence, we are willing to agree to the following procedures with respect to witnesses who were dead or otherwise legally unavailable at the time that your client was arraigned. We make this offer in the interest of fairness and ensure that you are able to provide the best defense possible for your client. And then the email goes on. I'm not going to address the rest of it, but in essence, the requirements are, it says that if a witness became legally unavailable before a defendant was arraigned on November 18, 2016, if they provide notice of their intent to introduce the statement or statements of specific witnesses no later than November 13, 2019, and that should they elect to offer that legally admissible statement of a legally unavailable witness as defined above, all other legally admissible statements will be allowed. I went on to say in the email that I have been bringing this up repeatedly. So the first question is, the reason they are not able to offer that hearsay is because they took a tactical approach and made a tactical decision that in the end, it was going to be worse for them if they presented it. That led to us finally, again, not arranging to subpoena witnesses who were outside of the country that would have, in fact, impeached these statements. And we based our case on that. I gave them 5 years, and then I extended it to November. So that's the first issue. They had the chance to present this evidence for the truth of the matter asserted. Motions were due in this case, Your Honor, more than a year, and the defense still continued to file motions that the court had ordered them filed a year prior. The court was generous and allowed those motions to be litigated. They filed a motion in the middle of opening statement in March of 2020 saying, you know what, we want to bring this evidence in, not for the truth of the matter, but because, in essence, it will corroborate Mike Strzok's investigation. And now we need to back up a step on that. The defense elected to call Mike Strzok as their witness at conditional examination. They elected to do that, and Mr. DeGuerin, in his questions, presented Mike Strzok for the idea that Mike Strzok did a competent and thorough investigation in this case. They did that knowing and having been given discovery of 25 horrendous things he has done in the case, including having sex with one of the witnesses. They then, in the questioning, lobbed it up there and basically said to Strzok, now you did as good a job as you could possibly do on this case. They made their own bed. Mr. Strzok got gutted on cross-examination, not because I'm a good lawyer, but because it's one of the worst investigations I've ever seen. So then we end up facing the situation where he's unavailable. We give them, I have emails back and forth where they agree to the transcript. They agree to it. We make edits, additional edits, based on their issues. We filed a motion very clearly that says that that transcript is going to be utilized. It is made clear that that transcript is based on the court's prior rulings. Now, the defense comes in and now they say that trained legal minds are different than 12 lay people. Well, that's a very good point. And the reason that they're saying that is because what they want to do is they literally, after all the opportunities they had to have the statements admitted for the truth of the matter asserted under due process, which they made a tactical decision not to do, they now want to say, Your Honor, we want to admit that not for the truth of the matter asserted. So in essence, the jury is going to be told, people saw Kathy Durst. But you're not to consider that for the fact that they actually saw her. You're to consider that only as it affects Detective Strzok's investigation. Under 352, that is an automatic, you've got to be kidding me. It's again analogous to us trying to bring in a confession of a defendant to then argue, but look at how nice we treated him, and that's an issue in the case. Now, the other problem is Detective Strzok, in his testimony, Your Honor, on 3 separate occasions, said that the reason that he did not investigate further was because of Dean Cooperman. Now, it doesn't matter if a second reason was because of the elevator operators, because even if that's true, Detective Strzok saying, I did not do further investigation because of Dean Cooperman, eliminates their argument. So, now we sit here, and now we have attacks on, I didn't even understand this, they're now saying that the mayors testified inconsistently, which the court is here, Your Honor, it's garbage. If they thought the mayors testified inconsistently, then they probably should have cross-examined them on those points. As the court's aware, when they did cross-examine them, basically the mayors rejected every allegation and every point that they made. So, bottom line to this is very clear. 1, the defense had the opportunity to have the elevator employee information put in for the truth of the matter asserted pursuant to stipulation. That offer was extended 5 years prior to the beginning of this trial. They never took it. They repeatedly rejected it. Number 2, they had the ability to challenge in more detail Mike Strzok's transcript. They stipulated to it. They're literally telling the court, Your Honor, as if what they heard yesterday, they're literally saying, oh my God, did you hear what Mike Strzok testified to? How could we have known this? It was recorded and you stipulated to the transcript. There was nothing new yesterday. it's as if yesterday is the first time they actually heard it, which obviously is not the case. They heard it in the courtroom the first time and they saw the transcript. So, for all of these reasons, Your Honor, the court has made this ruling. This is, by my count, the 6th or 7th time that they have brought this issue up. So, with that, Your Honor, we would submit. Appreciate the indulgence. That was for the record on appeal.
So, also, there have been these citations. The idea that a prior identification would be a basis for admitting this prior identification after the fact, or after she is supposedly, after she disappears by someone who knew her under 1238 of the evidence code, that requires that the witness testify that he or she made the prior identification. The other premise here is the ancient documents, 1331. I don't believe that applies. I mean, that's primarily for real estate issues, but here it has to be something that I don't think something that's been in controversy for 30 years is then somehow grandfathered in.
None of the hearsay exceptions. So the reason that I did not address the authority they gave is because, number one, those hearsay exceptions would introduce the statements for the truth of the matter asserted, which they cannot do. They are also, as the court indicates, every exception they gave is inapplicable in this case for different reasons.
Yep.
Prior identification requires the witness to testify. They're not here. The ancient writings exception, for the reasons the court indicated, is also inapplicable in this situation. The cases they've cited are completely inapplicable.
You
in
know,
this
the
situation.
ancient documents exception is very creative. I got to say that when I saw that, I looked that up. I thought that was good, but I think it's real estate. It's not an ancient document that people disagree about. Mr. Chesnoff, did you want to explain that further? Or you just want credit, accolades for the creativity?
Thank you. That and a subway token will get me in the subway, Your Honor, but I appreciate it. Just wanted to add for the record, Your Honor, ironically, if this case, Kathy Durst's case, was being actually tried in New York, the New York Evidence Rule 8.01b states that the federal and the New York state constitutions require the admission of hearsay not encompassed within a hearsay exception when the declarant is unavailable to testify, the hearsay is material, exculpatory, and has indicia of reliability. So I put that in the record for future reference. But
In New York, you may...
well, that's the ironic part of it, Your Honor. He's being prosecuted ostensibly for a New York murder here, and I've made my record. Appreciate the opportunity.
Not really, and if it makes any difference, I mean, I don't think this is res judicata on that issue either, right? I mean,
No,
if there's a concern about liability, just it doesn't resolve that issue. So, yeah.
I was neglecting to mention one last issue.
Yeah.
Although the court is obviously correct in its statement that we do not technically have to prove that Bob Durst killed Kathy Durst.
Right.
We are absolutely within our rights and within our responsibilities in proving the special circumstance to prove that fact.
Well,
and that's what we're doing.
Well, here's the thing. I mean, it's relevant. Clearly, it's not the ultimate fact. It's an intermediate fact. That proof really tends to prove the closely related aspect that that he would be a suspect and he's likely to be prosecuted for a crime because he committed a crime and because she, Berman, as a witness to a crime. I'm not saying that that's irrelevant.
The court is just saying that technically we don't have to prove it, but obviously the fact that we are proving it enhances the argument that in fact the special circumstance is true. So with that, Your Honor, we would submit it and hopefully we're ready to go.
Anything else?
No, thank you.
Thank you. Okay, our jurors here. And who's the witness?
It's going to be Elizabeth Jones, Your Honor.
Okay.
Do you want me to have her enter or wait until the jurors enter?
Jurors first.
Okay. He's here.